Ladies and gentlemen, welcome to the webinar. Today's seminar topic is Paycheck Protection Program for Small Businesses in the CARES Act. Our presenters today are Paige Minch and Skip Sell. If you'd like a copy of today's presentation, you'll find it in the handout section of the webinar interface. Similarly, in the webinar interface, you'll see a section for questions. If you have a question, you can type in your question there and send it to the presenters. Please take a moment to find that area of the webinar interface for questions and handouts so you can follow along with us. With that, I'll hand it over to Skip and Paige.
Tony, thank you. Paige and I welcome any newcomers to our latest conversation about the legal issues of the day. And for any returning friends, welcome back. We're discussing the Paycheck Protection Program, which provides small businesses employing less than 500 people with low interest loans up to a maximum of $10 million. The loans have many favorable features, including no personal guarantees or collateral required, and payments are deferred for 6 months. Best of all, part of the loan could be forgiven and not counted as income so long as the money is spent on certain operating expenses the first weeks after the loans originated. Now, we're going to be discussing the Paycheck Protection Program from the borrower's perspective, and we'll focus on this new loan program to answer questions about who, when, where, what, and how of the program. Who can apply? When can you apply? Where can you apply? What do you need to apply? How much money can you get? What can you use the money for? And when is the loan due for repayment? And then finally, how much of the loan can be forgiven? In answering those 8 questions during this conversation, keep in mind that the purpose of the law is to provide forgivable loans to small businesses, to provide funds to pay their employees and certain other costs to continue business during the 8 weeks of this COVID-19 pandemic. That purpose will determine how much you receive, how it should be used, and how the loan will be forgiven. Now, this presentation is going to be a little different from other webinars. Well, we're not going to be pontificating or lecturing. It's more in a conversation format because this is sort of everybody in the same boat trying to figure out things that are happening very quickly. We've got team members behind the scenes that are looking at the news as it's coming out. If we can provide any additional information, we will. We have other lawyers other than Paige and myself in the background looking for questions and also assisting. That includes Catherine Jones and Teresa Phillips. And we are going to be here for you. So with that in mind, ask any questions you want by email. As I said, we're going to be focusing on applying and getting the loans, but if you want to turn that focus a little bit more towards forgiveness later on, if we can get to it and you want that, let us know by email. So this is all happening very quickly. And Paige, can you start us off with the background?
Sure. Just to kind of move forward, you did a great job with what the purpose of the loan is, to help these small businesses keep their workers employed during this economic downturn. So we'll go ahead and turn to who's eligible for the Paycheck Protection Program. And generally, any small businesses with fewer than 500 employees will qualify for this program. That also includes nonprofits, sole proprietors, independent contractors. So the number of persons who are eligible is great.
What about the gig economy?
I'm sorry?
Gig businesses.
Oh, sure. I mean, the qualifications are based upon the number of employees that you employ. So this includes individuals on a full-time, part-time, or any other basis. It's very expansive with that.
So if a small business meets the criteria, then what does the small business have to certify in applying for the forgivable loan?
Sure. So on the loan application, there will be 4 things that you need to make a good faith certification regarding, and those include just acknowledging the uncertainty of the economic conditions, and that's why you're making this loan request. It's necessary to kind of combat those conditions. You also have to state that you are using the funds for the specific costs that are included within the CARES Act, which means the payroll costs, making certain mortgage payments, certain rent payments, and utility payments. But you have to be careful with using the funds for things other than the payroll costs, because the Treasury Department did come out with some guidance saying if you use more of the loan, more than 25% of the loan proceeds for costs other than payroll, then that amount may not be forgiven with that. And then also that you don't have a pending loan application or are using another loan for purposes that are duplicative of what this payment protection loan is for.
So you can't have dual applications at two banks at the same time? Is that the concept?
That's the concept,
okay.
Yes.
And what happens if you make an application to an SBA approved lender and that application gets denied? Can somebody go ahead and make another application?
It's a little uncertain at this point. We're still working through that process, talking with some lender contacts to figure out the appropriate method for that. So at this point, I'd say just keep in touch with the lender that you're currently using or contacting regarding this payment protection program to see what their procedures would be.
The point that Paige made is really important, because even when we were continuing our preparation for today's webinar, the news was coming up that even though this is supposed to all be starting today, 9 o'clock this morning, yep. Everyone's scrambling because this law was just passed 7 days ago. And so they're trying to get their programs in place. And this is a momentous task because you're thinking about this nationwide. And it's a lot of money. So we're still trying to see what banks are ready to move it, which is good news for you in a way, because you're going to have a little more time to get all your ducks in a row. And one of the things we want to emphasize right at the beginning, the program's open today to start applying if banks are ready. You need to be ready. You need to act on this expeditiously. And the reason is because there's a limited amount of funds that are available. And somebody, a client mentioned this is kind of like Black Thursday, right? Because Black Friday, thank you, Teresa. Black Friday, because you want to get in if there's something available, and it's a limited amount that is available. So with that in mind, Paige, how much loan money can a small business potentially receive, and how is that amount determined?
Sure. So the CARES Act provides that the maximum loan amount that a eligible business can receive is the lesser of $10 million, or the calculation of your average total monthly payroll costs during the 1 year prior to when the loan was made, multiplied by 2.5. So essentially your payroll costs for 8 weeks moving forward is what this calculation is intended to capture. And so the important piece of this is the total monthly payroll costs that you need to figure out for the 1 year period prior. And then also for that 1 year period, it is a little different if you're a seasonal employee. So you have different periods that the loan application will, or the supporting documents you need to submit for your payroll records as a seasonal employer.
So when you go through the formulas that you're describing, payroll costs are the key, right?
Correct.
How does the law determine what is included in payroll costs?
Okay, so there's a list that's provided of what payroll costs include and what they do not include. Some of the costs include an employee's salary, wage, commission, or any other similar compensation. It also looks at things such as vacation, family or medical or sick leave payments made, and then payment of retirement benefits by the employer. Any payment of group health care benefits are some of the big ones to look out for, is what's included.
So when the businesses are looking at these payroll costs, it's for the purpose of filling out the application, right?
Correct.
And on the application, are these all listed out like that, or is that something that the businesses have to go to with their financial folks, figure it out, and then put one payroll cost figure down? Did that make sense?
So as the businesses are filling out the application, whether it's through an online portal with their lender or if the lender's accepting the application forms from the Department of Treasury and the SBA, you should have the average monthly payroll amount already calculated so that it can be input into the proper application form. So this information is provided within the Act for reference as to what needs to be included and then what should not be included. So
Is there a wrinkle for compensation levels?
there is, and so we'll move forward to what payroll costs do not include.
Before we do that,
Sure. Sure. So also with the payroll costs that are included, this does include compensation for a sole proprietor or an independent contractor is what this slide's referring to. So if we go one more ahead, so the payroll costs, this is what should be excluded from the payroll costs, and that includes any compensation to an employee that is in excess of $100,000 for that annual period. It also excludes certain payroll taxes and income taxes, compensation of any employee who does not reside principally in the United States, and then anything that would qualify as sick leave wages under the another recently passed act, Families First Coronavirus Response Act. So those are elements that you would then subtract from what you just determined were included in those payroll costs to determine your total payroll costs.
Okay. Is the takeaway that the higher the allowable payroll costs, the higher the potential loan amount? Potentially?
Potentially. Mm-hmm.
Okay. With all of these loans being out there, are the terms the same for everybody?
Sure. So the terms will be the same for everyone. Some of the loan features, it will be a 2-year loan. The Treasury and the SBA just as recently as last night put the interest rate as a 1% fixed rate, kept the 2-year loan period. There's no prepayment penalty. And then once this loan is dispersed, or if the eligible business is approved for the loan, all payments are then deferred by the lender for a 6-month period. There's no fees for these loans. It's non-recourse. No personal guarantees must be given by the owners of these businesses, and there's no collateral requirement. So a lot of things are relaxed. The most important thing is to look at the interest rate that's fixed at the 1%, and it's a 2-year loan essentially.
All right. So the businesses go, they figure out the payroll costs, they figure out what can be included, what cannot be included, they do the application, they get the loan. When they get the loan, what can they use the proceeds for? And does it make a difference for anything?
Okay, so there are allowable uses of the loan proceeds. So these include payroll costs, which this payroll cost definition is the same as what we just discussed, listing what can be in payroll costs and then what you have to exclude. So you look at that for the covered period. Any costs relating to any group healthcare benefits, any interest on a covered mortgage obligation, rent, and utilities. However, just keep in mind that this loan is meant to maintain your employees during this 8-week period after the loan is originated. So payroll costs are a high priority for this loan. So the Treasury Department made sure to mention that if 25% or more of these loan proceeds are used for things other than payroll costs, that portion may not be forgiven. So they're trying to keep it 75% for payroll costs, and then the other 25% could be used for these other purposes.
Okay. Can you clear this up for me? So once you get the loan, you can then use it in the subsequent 8 weeks for different costs. When it talks on this slide about using it in that 8-week period for payments of interest on any mortgage obligation, rent or utilities. For the mortgage obligation, the rent obligation, the utilities obligations, are those obligations that have to arise before the loan is taken out?
Yes, so those rent, utility, mortgage obligations, the debt obligations, they have to arise before February 15th, 2020. So this is for prior debt that was incurred by the business to help them maintain.
Okay. So my takeaway on that is that the loan is set up to try and keep businesses going like they were before, with the goal first to get payroll, and then there's money left over, and the money's available then to use pre-existing obligations for interest payments on mortgages, lease payments, and utilities to keep the business going in the next 8 weeks.
Correct.
Is that fair?
I think, right. And just to kind of go with that further, the government or the SBA, I think they're just wanting to make sure that the businesses are allocating appropriately. So they're keeping that in mind, that the payroll is, like you had mentioned, or the employees are kind of that number one priority.
Okay. So we've been talking about the who, the what, and how for a while. Can we shift, even though it's changing, it seems like every second, to questions about when these applications can come in? What are we expecting once they're in?
Sure. So I'm sure as everyone's aware, the date, today's date was the date that was targeted for small businesses and sole proprietorships to start applying through the lenders to receive the Paycheck Protection loans. Banks that are already existing SBA lenders are essentially automatically approved to make these loans. They are, from what we've read last, the SBA is also having more lenders come into play as well, so borrowers have more options of banks. However, I haven't seen an updated list quite yet. So the SBA lenders, you need to look for an institution that is an SBA lender.
And they can find the updated list on the website.
On the SBA's website, yep, they have a list, and I'm assuming that they'll also be updating that with the new qualified lenders for this Paycheck Protection Program.
And they don't apply online with the SBA. They apply with the lender, either in person or online, or just online.
Right. So most of the lenders that I've seen their websites are have indicated that they would be doing the process online. It's still, the banks are still working through that process at this moment, but from what I've seen, it seems to be moving towards an online portal that the banks will open up and have the applicants then submit the proper documents through the specific lender that you're working with.
Okay.
Oh, okay. And just one last thing on accepting applications, the target date for the independent contractors and anyone who's self-employed, that was targeted for next Friday, April 10th, 2020. So it's kind of a staggered approach here for this Paycheck Protection Program. Okay, so we have been focusing on the elements of getting and using the loan. So we're going to transition now into dealing with, once you receive the loan, then the forgivable nature of this Paycheck Protection loan.
So there are some key takeaways on the forgiveness of loans. First, up to the principal loan amount will be forgiven if the loan proceeds are used to cover payroll costs, as we've been describing, and most costs to cover mortgage interest, rent, and utility costs over that 8-week period after the loan is made. And this is an important part to remember: the employee and compensation levels are maintained. A small business can owe money when the loan is due if the loan proceeds are used for anything other than payroll cost, mortgage interest, rent, and utilities over that 8 weeks after getting the loan. And the guidance we've seen from the federal government says that due to the anticipated high volume of subscriptions to the program, it's likely that not more than 25% of the forgiven amount may be for non-payroll cost. A small business can also owe money if you do not maintain your employees and their payroll. To achieve loan forgiveness and to avoid owing money, businesses need to spend at least 75% of the loan proceeds on payroll costs, 25% of the loan proceeds on mortgage interest, rent, and utility costs, and keep your staff and payroll the same. Remember, go ahead, Paige.
Okay, so just to kind of sum up what you were mentioning there, so the total loan forgiveness can't be more than the principal amount,
right,
essentially, but then the total principal can then be reduced in 2 different ways.
Right.
Right.
That's correct. If you decrease your full-time employee headcount, or if you decrease the salaries of wages by more than 25% for any employee that make less than $100,000 as annualized in 2019. Okay, but this exemption is very important because this is what we call a safe harbor provision in the law, which means even if you had to lay off people, and even if you had to reduce salaries to keep in business, so long as you follow this exemption restoration provision in the law, it still can be forgiven, okay? So a business has until June 20th to reestablish the full-time employment of its employees.
June 30th.
Oh, I'm sorry, June 30th, thank you. And the salary levels for any changes that you made between February 15th and April 26th. One other note, and I think Paige mentioned this before when I was switching back and forth in slides. Payroll costs, eligibility for loan forgiveness will not include annual compensation greater than $100,000 for individual employees.
Mm-hmm.
So when we get to that stage, a condition to seeking forgiveness is that you have to have the appropriate documentation and you have to make an application. Now, different from the beginning part of our presentation where we're starting to get some guidance from the federal government and we're starting to see from secondary sources interpretation of things, because this forgiveness is a couple of months away, we're not getting the same guidance yet, except for what we're seeing reading the law black and white as it's printed. And so here's what we know that you need to do. And it's stuff you're probably doing already, but you need to have the documentation for it. You have to have the payroll tax filings for the IRS. You have to have state income, payroll, and unemployment insurance filings. You have to have canceled checks, payment receipts, and other documents that are going to show verification of the payments that you've made for the mortgage interest, your utilities, and your rent. And then you're going to have to do this application. And just like Paige was describing the certification at the beginning of the process, you would then have to do another certification that you have used this money properly, that all the documentation is true and correct and accurate.
Mm-hmm.
One other issue that came up is timing, and the lender is supposed to issue a decision on the application within 60 days after receipt. Another issue that's come up, though, that we're not sure the answer right now, is what happens to you when you make the application for forgiveness and it's denied. We're not sure. We don't know if there's an appeal process.
Right. Yep. We're not sure about that. However, this is essentially a loan that you would be taking out with the SBA through that lender. So essentially the loan terms would carry forward for that amount. So keep that in mind as well. It would continue at that 1% for the 2 years with the deferral of the 6-month payment deferral. So those would be the terms.
Is there a maximum maturity date for any of those loans? Is it always 2 years, or can it be expanded out?
As far as right now, they've said the 2 years, the guidance we've received.
So if the loan amounts are forgiven under the law, it's considered canceled indebtedness. And that means that the amount forgiven is excluded from gross income for tax purposes. After that happens, then the administrator will remit to the lender the amount equal to the amount of forgiveness. And then there's some other provisions that,
Right.
you know.
And this may change. This is directly from the CARES Act, and the SBA and the Treasury has been providing additional guidance. So this is kind of more of a fluid process right now, because obviously they're working on the application process. So this may change a little bit, but this is essentially kind of the steps. They'll have to remit a report, and then a decision will be made in some fashion.
So before we start with questions, I just want to have Paige and I talk amongst ourselves with you listening about what we're seeing for you with the availability of the law. There's funds here. Act quickly. Get your applications in. Work closely with your lenders. There's a limited amount of funds available. Get it in so you have a chance to get it. It's forgivable if you follow what the law says and you apply the loan proceeds to the appropriate cost. There's even a safe harbor if you have to lay people off, or you've had to lay people off, or you have to or had to reduce salaries. You bring them back up, you can get more forgiveness that would otherwise be reduced. So with that, we can open it up for some questions. And
okay, we've had quite a few questions.
we're going to make sure we're trying to avoid the echo, folks. Bear with us one second.
Okay, we've had quite a few questions on how we calculate the payroll cost. And I think you went through some of these, but some people are looking for clarification. For example, is payroll cost going to include costs paid to independent contractors that work as employees and do employee type work for the company?
Sure, I can take that question. So at this point, from what we've been seeing online and different things, and with the eligibility requirements for this, the Paycheck Protection Loan, it appears that the independent contractors could apply for this Paycheck Protection Loan on their own behalf. So therefore, the 1099 may not need to be included within your payroll compensation amounts. You can, I would say, double check with your lender as well to see if they have more clarification on that.
I have a couple of questions that have been coming in through my email in addition to the PowerPoint presentation. And one of them is, we're not sure that we need the loan now, but may need it later. Should you apply now? And my answer is yes, because when you think you need it, it may not be there. There might not be available loans. I don't know if you apply for it and you get it, that you necessarily have to take it. What are you going to say?
Have to keep into consideration that the covered period for when you go for the loan forgiveness is for that, essentially that 8-week period after the loan originates. So you have to keep that in mind, that essentially when you're applying for forgiveness, the documents that you're going to be providing were for those funds used.
But isn't there also a term limit for when the program ends?
June 30th.
And so the latest they could do it is June 30th. But the point that we're trying to make is there may not be funds available by June 30 if you wait. Another question that came up on my email was somebody had already applied online for disaster loan assistance with the SBA under another program. Does that application preclude me from Payroll Protection Act loans?
Okay, so we're still working on gathering more information about this as well, but there may be a ability for the businesses to receive both loans, but how that plays into the potential forgiveness of the Paycheck Protection loan is we're still looking into that at this point, but there has been a little bit of guidance provided that leans toward the businesses may be eligible to receive both. Just need to look into the specifics more to determine that.
One of the questions we have that's come up in different forms here is when some small companies that are sole proprietorships, they pay themselves, a lot of their income comes through dividends as the owners or something of that sort. Is there any way they can use that as payroll costs? I think if you look at the clear definition, if it's a true dividend, that might be an issue.
Mm-hmm. Possibly.
Yeah, honestly, I don't know the answer right now. And I think that's one of the things that we're going to have to look at. But I think it's a great question. And I thank you for the question.
Some of our viewers here have sent in questions about if they're right now, they've increased people's pay as sort of a hazard pay. Is that increase going to count or how will it factor into their payroll cost calculations?
From my understanding, the payroll costs are calculated from the 1 year prior to the loan date. So if you increase those wages a couple months ago, essentially, then that could potentially be within your payroll calculation. So it could affect it.
But probably the likelihood of increasing it for hazard pay related to this would have been more recent and not in that time period.
Yeah,
I'm thinking.
Yep.
We've also had some questions about affiliated companies. If you asking if there's SBA leniency or changes so that when affiliated companies apply together and they exceed this 500 employee threshold or other thresholds, can they be counted towards some other definition? I think we had talked about this maybe off camera before, that there is some categories that depending on what your industry category is, what code you have, they have made some exceptions, but it's very limited. So it'll depend on what kind of industry you're in. For example, restaurants are one that they're giving them a little leniency and letting them count location by location. Someone's asked when they apply, do they have to make it, if they have affiliated companies, do they have to make application for each company? But my understanding is generally under SBA, you make one for all your affiliated companies.
I know on the previous form that the Treasury Department put out that you had to check yes or no of whether or not you had an affiliated company. So that was one of the questions on there, and then they may need additional information regarding that.
And the SBA guidelines, they tend to be pretty complicated. Looking at them, that what they considered affiliated may not fall in the commonly used definition. Probably a good idea to get some guidance on that when filling out the application if you're not sure. Now, I get a lot of questions about calculating the taxes for both payroll costs and the deduction, and then paying them through the covered period. I think people are picking up on there's a little, sometimes it can be read inconsistent on what exactly the timing and things like that. Could you clarify for our viewers and those listening what federal, specifically on the federal taxes, the FIT, the SS, and Medicare, how they should be treating those for payroll costs when they're calculating them?
Sure. So I can try to address this with, so the payroll costs within the definition that was provided, it talks about a covered period. So from what we've kind of been gathering, and different things. The covered period has a different meaning if you're in section 1102 of the act, or if you're in section 1106, the forgiveness portion of the act.
Just for clarification for everyone listening, 1102 is the section of the law that deals with the application and approval process and talks about what's included, the how, the when, the where. The second section, 1106, is the one that deals with forgiveness. And
right.
the definition is differently used in each section.
Right, so depending upon what section you're looking at, the covered period could either be for the period of February 15th, 2020 through June 30th, 2020.
Which section and what does that period apply for?
Is section 1102 when you're figuring out and applying for the loan.
Okay.
And then section 1106, the covered period transitions to the 8 weeks after the loan originated. So depending upon when you're calculating those payroll costs, you need to keep in mind the covered period that the definitions are looking for when calculating those federal payroll taxes.
Another question came to my email, which was asking about how to keep the cost allowed and documented. And the question was, do you think opening a separate checking account only for the loan amount, which I assume means how the loan proceeds are going to be used, makes sense for keeping the documentation simpler?
I mean, if you're able to do something like that, I think that would be a great idea to keep it clear and concise about you're spending this amount for such costs and then this amount for such costs, so the funds don't become commingled, and whatever makes it easier for the lender to understand what you spent those expenses on, the loan proceeds on, I think would be helpful.
Just to emphasize, I keep getting so many questions even after we've answered this about 1099 employees, independent contractors. Generally speaking, those costs aren't going to fall in most employers' payroll costs because those folks can also apply under their own business umbrella. Is that correct? Again, it's going to go to the true classification of the employee. Sometimes we use these terms loosely and we think 1099 is always an independent contractor. And there's a lot of definitions that overrun here, but go right ahead.
Sorry. And also with the in certain definitions, that the salaries of the independent contractors or the sole proprietors, those are included as the compensation with that. But then, as Teresa was mentioning, the independent contractors seem to be eligible to then apply on behalf of themselves to then calculate everything. So from what we've seen, it seems that they're able to apply themselves.
What about bonuses and incentives that a company normally gives? Do you see where that could come under the definition of payroll costs?
The definition of payroll costs is pretty expansive. So within that first kind of bullet point of the payroll cost, it talks about salary, wage, or other similar compensation. So assuming that the compensation is a broad term, you'd have to consider if your bonuses would fit within that definition of salary, wage, commission, or other similar compensation.
Someone has asked, have we heard about any kind of loans that are just available and designated to the compensating for lost revenue during the period of the shutdown? That might go a little outside of what we're talking about today, but I just thought I'd pose, has anyone heard anything like that?
I haven't heard anything that is currently passed about that, but I am hearing that other stimulus type packages and loan packages and relief packages are being considered through the normal legislative process. Where those are at, I don't know, but I expect that there's going to be other rounds of this as we continue on in the next several months. And so our advice to everybody is to keep looking. We'll try and update as possible too, but this is going to be fluid. I mean, we've been looking at things coming across line as we've been presenting, because we're trying to keep up to speed. Everybody needs to, because the fluidity of this is going to be rapid.
have a pretty nuanced question here from one of the listeners. With regards to people who have just done maybe an asset sale, an asset acquisition where they didn't obtain the company or the entity, but they obtained the assets, and maybe they didn't do that. They didn't obtain the assets until after that February 15th cutoff. Is there any way they can, even though they've continued the business under a new umbrella, new entity? We were looking at, Catherine Jones and I were just looking at the some of the regulations on that. Is there a way that they can use the previous payroll? You know, generally you would think no. I mean, they're not the same employer and things like that. But we are seeing some language in some of these definitions and things that seem to anticipate if you weren't otherwise operating on February 15th, there might be other ways to get around it. So it's that might be one of those issues you would have to maybe seek a little bit more guidance. It's not something we can probably give you a good straight answer. You'd have to look at the situations to see if you can make them fit into one of these exceptions that this long bill has set forth here. So how about the restoring employee part? Do you have anything to add about what kind of time frame they're looking at, where they have to, how long they might have to keep the employees or anything like that? Or is that something that we're still seeking some guidance on?
If I think I understand the question. The question is, if you're trying to get into the safe harbor section of the law so that your forgiveness amount is not reduced and you rehire somebody, or you go ahead and bring their salary level back in order to get into that safe harbor, how long can you keep them, or how long can you keep their salary? And it doesn't say.
Are these loans, are they like some other kind of federal loans?
Well, look, Paige and I were looking at it, because I think what they're trying to figure out is, if you go ahead and you try to get the maximum forgiveness by bringing somebody back on board, or bringing somebody's salary back up, and you get the loan forgiven, can you just go ahead and terminate them and reduce their salary? It doesn't say, but I'm thinking, you know, you may, before you do it, you better check the guidance, and when that comes, right?
Right, and remember the overall purpose of the
Is
loan
to keep them,
keep them
employed and keep their salary. But the question goes to, what happens when that period is over?
Have you read anything yet about, if, like a lot of government loans, if the borrower dies or the company dissolves, sometimes they're either just forgiven or they're dischargeable in bankruptcy. Have you seen anything where how these are going to be treated for those kind of purposes?
No, but it says it's non-recourse, and you know, typically non-recourse in legal jargon means that's it. You know, you're not going for collateral, you're not going for a guarantor. It's not that there's co-obligors that are going to be responsible for it.
There are potential criminal penalties if you like knowingly misuse or trying to do something that's not proper. But
well, actually, you know, that's a really good point, going back to a question or two ago, where if you had the intention that you were going to get a loan and you were going to finagle the system and then go ahead and terminate your employees right away, does that bring that up? Well, it may. I mean, remember, we started off the webinar with the idea that the purpose is to keep people employed and maintain levels of employment and salary to get you through the next 8 weeks. And the way the statute is set up, it's set up with that purpose in mind, to figure out how much you can get, who can get it, what you can use it for, and when you use it, how it will be forgiven based upon that use.
Okay. One just asked for clarification. Can you repeat that covered period that falls under 1102?
okay.
Sure.
Sure. So with the section 1102, that definition of the covered period, so that definition of the covered period is February 15th, 2020 through June 30th of 2020 is what is determined as the covered period. The period beginning on February 15th, 2020 and ending on June 30th, 2020. For the section 1106, the covered period is the 8 weeks after the origination of the loan. So you just have to keep those time periods separated in your mind when you're figuring out the calculations for section 1102, and then after you obtain the loan, then the calculations for section 1106.
With regards, I know there's going to be a separate application process that starts next week with independent contractors and the like. Are their loans going to be just targeted for utilities and rent, since they don't have employee payroll per se? Or would it depend maybe on the structure?
Let me noodle on that first. That's a really great question.
There may be additional guidance coming out regarding that as well.
That has not been addressed that I've seen, but that is a really great and interesting question. I don't know the answer.
Some people are seeking clarification with regards to the application and then the later application to forgive. In both instances, is it the lenders that are making the decision on whether you're eligible?
Yes.
So there'll be no oversight by the SBA as far as we know on that.
Yeah, not that we know of, yes.
Well, the lenders are determining eligibility, but then they submit and verify to the SBA that everything is correct, and because they're supposed to be verifying the amounts that are submitted through the application.
Right, but is there, means the SBA coming back and with oversight saying to the lender, you can't approve that, you can't forgive that. It's the SBA lenders that are running that side of the show.
Yep.
I know this is something we've been bouncing around, but some people might be asking, if I turn in my application, I think I've met all the criteria, but I'm denied for whatever reason, what's my recourse? I don't think there's a clear answer yet.
There isn't, and it's bugging me too, because it's going to happen, and there's limited funds. So the idea is to, and the banks are dealing with this too, because you can see some of the announcements this morning from the banks. Sorry, we're not ready for your applications, but we want to make sure we do it right. And everyone's going to be going after these funds. We're trying to get our ducks in a row, just like all the applicants that want to be borrowers are going to be doing as well.
A lot of people are trying to simplify some of the things you said, and I think they're just looking to see if you think this is yes or no. What a lot of people are anticipating is they're gonna use their last year payroll and calculate and get more funds than they might need going in the future, anticipating slower business in the next few months and things. Is that going to affect? How is that going to affect their forgiveness? Is that essentially going to make it non-forgivable, or will it just affect the percentage that's forgiven?
I'm not sure.
I think what their concern is, they'll get a loan based on payroll costs that were higher, but they won't pay out that much in payroll costs going forward, because they'll have a lot more of a reduced workforce. So they may be in a position of either having leftover funds or using those funds for rent or utilities. And as long as they're using them for covered costs, I would think that the forgiveness.
Okay, I understand the question. I think the guidance is that right now they do not think that there will be forgiveness for loan proceeds used over 25% for the mortgage, utilities, and rent. Their idea, I think, is they want 75% for payroll costs, and then 25% is available for other things. But I don't know how much it's. Here's what I think. I think that the question is going to, we get, let's just pick a number. We get $300,000, and we only have to use $100,000 towards payroll, and we've got $200,000 left. If we use it for things other than utilities, mortgage, and rent, will it be forgiven? And no, I don't think it will be.
A lot of people are asking about, can you clarify the difference between the EIDL loans that are available, the emergency loans that are available, and the loans that we're talking about today under the PPP, and how they differ, and why maybe a potential employee or business that's looking to this would maybe want to take one other than the other. As I understand it, probably the con with the emergency one is it's just a one-time payment. It's not based on anything other than up to $10,000, I think.
Well,
So
that's the first part of it, is that the business could potentially get essentially an immediate payment of the $10,000 from the lender. From what we've seen in different things, the EIDL loan, it appears to have a maximum loan amount of up to $2 million. So there are some differences in the actual terms of the loan. Haven't researched it as much as this payment protection program, but there does seem to be a few differences. The interest rate could also be different, and then things such as the term, the payment deferral. I'm not certain if they're going to offer the same deferment terms for the EIDL loan. So little things like that. If you look into it a little bit more and become more familiar, it may fit your situation better than this payment protection program. So.
We do have a lot of people commenting that they're having issues submitting applications, that some banks have told them they're not ready to accept applications. I know we've been keeping our ear to the ground and checking in with our various contacts, especially in the local banking community. And everybody was hoping to be ready this morning, but I've yet to hear of anybody who's actually accepted the applications. Have you heard anything different yet?
I'm only hearing that people aren't ready, and they're trying to get ready, just like we're trying to help our listeners get ready. And we're all trying to get to the same goal: stay in business, get the money we can as quickly as we can, keep people employed, keep income at a level if we can, and work through this together.
Yeah, and I would just keep in touch with your lender to see if they have an expected timetable of when they think they will be accepting applications, or just trying to stay in touch as much as possible.
I would try to get a personal contact, and I would try to develop that personal contact. I would ask for an email when they're ready. I'd ask for a phone call when they're ready. Will you mind if I keep bugging you? I mean, whatever you can set up with your personal contact so that you can get it submitted when you're ready.
I do know that a lot of banks through their websites are actually posting kind of updates and statuses, and trying to be as forthcoming as they can, essentially, with the timing. So I would also check on the websites of the lender that you're potentially going with to see their timetable if they have one.
I see our time is coming to a close. If we didn't get to your question, we'll try to answer it privately or directly. Feel free to email us. The email addresses are there on the website presentation. And just so you remember, Ms. Minch's is MINCH at FBL-law.com, and Mr. Sells is SELL at FBL-law.com. I'm Teresa Phillips, and mine is Phillips, PHILLIPS, at FBL-law.com.
We thank you very much for listening. Be safe out there. Thanks very much.
Thanks, everyone.